the record.
Let's get things off Alexis.
Did I say that on the record or not?
No.
All right. This would be case D 553455, the Zamora case. Ms. Perry is present in court with her client. Mr. Frizzell, can you hear me?
I can, Your Honor, and I'm present here in my office, and my client's in here as well.
All right. We continued the matter last time because Dr. Holland was keeping us all in suspense as to who she was more inclined to designate as. And again, all this is just a recommendation from an outsourced evaluator. Let me be absolutely clear. I don't rubber stamp. They do, by local rule, come in as court's exhibit at the time of the evidentiary hearing, if in fact we do go to an evidentiary hearing. And I'll reiterate the rule because she was a little apprehensive or wanted to make sure that the clients did not for some reason get possession of the actual report, but clearly the recommendation had needed to come out and be discussed. All that being said, she did, it was unambiguous that she was referring or making the recommendation that the plaintiff have primary physical custody of the children. So Miss Perry also started off, and I said wait so we can put the things on the record. She had indicated that she's got a letter in her hand, and I'm a little apprehensive to look at it since you have not seen it, Mr. Frizzell, but apparently North Las Vegas is not going to acknowledge my order because for some reason it involves possibly juveniles that are not part of this case. And if that is the case, and if in fact we do need them ultimately, then I guess as a second consideration, clearly Judge Voy, being over the juvenile division, would have the right to sign off on that, and I would assume that they would abide by that.
Your Honor, it doesn't
Sure.
say whether it's juveniles of this case or not of this case. It just says it involves juveniles.
Okay.
So,
Well, I'm
but they were
very perplexed because if first of all, again, I'll have her get it to you, Mr. Frizzell, but you know, being the ex parte communication, I'm very paranoid about that rule. I won't look at it till after you have seen it, and then if we have to take any action after that, I guess we'll start with, I'll talk to our staff legal counsel to see if they can talk to North Las Vegas legal counsel as to why they're not abiding by a district court order for release of records. But let's take even one step back further than that. Given the recommendation by Dr. Holland, Mr. Frizzell, is your client possibly amenable to you and Ms. Perry working a situation out based on her recommendations?
Well, I mean, ultimately, you know, this was at least a shocker to my client that it would, you know, and I would note that right away in her custodial recommendation, you know, she said that the kids, you know, the kids have been in her Melody's care since the May incident and appear to enjoy their mother and see her as a source of support. And, you know, it appears to me that, you know, Dr. Holland's main impetus is the few incidents that she outlined in her original report, saying that Melody is, I believe the term she used was gatekeeping, restrictive gatekeeping. And, you know, I can see where in a vacuum she would come up with, you know, she could make that determination. But, you know, my problem is, and I guess to answer your question, consistent with Dr. Holland's recommendations, I don't think my client's in a position to just all of a sudden switch the kids over. And I think that even so, 2 or 3 weeks is not enough time to do any kind of wholesale change like this. I think that my client would be amenable to Your Honor not making an order consistent with Dr. Holland's recommendations if we could sit, Mrs. Perry and I could sit and try and hash this out now that at least we have a certain way to go, because I'm my main concern, Your Honor, and this is things like the kids at this point. They don't have a bedroom. With the 2 kids there's going to be 7 children and 2 adults with 1 bathroom, and I believe that Mackenzie sleeps with Joshua and his new girlfriend, and Xavier sleeps on a sofa. And I mean, it certainly could be a loving household otherwise, but to me and to I think I've had cases in the past where DFS has been, well, the kids don't have their own bedroom and it's not healthy that they that kids are sleeping with dad and a new girlfriend. I have some serious reservations about that.
Well, let me stop you right there, because I can see the child sleep in your bed with you.
Yeah, because she gets scared of sleeping, on the bed or whatever. So in the middle of the night, she'll get up, and jump in the bed.
Okay.
And half the time I'm at work anyways, so she'll sleep next to Kelly, just for, I guess, maybe comfort, knowing that somebody, is there if anything happened.
Okay. Well, Mr. Frizzell, listen. I mean, you can, and I understand your job is to point out all of the parts of the report that favor your client and that are not positive to the plaintiff, and of course Ms. Perry's job is to do just the opposite of that for her client. I realize that, but that's not going to get us where we're going today. If you want an opportunity to sit down with Ms. Perry before we have a trial, that's absolutely, but at this point, I've at least got to increase his time without prejudice. Right now I show that he has Thursday to Friday, but again, I'm probably going to give him at least 1 extra day added on to either the day before or the day after to edge into again, temporary without prejudice joint physical arrangement, noting again that Dr. Holland's actually recommending that he have primary. So, and
my client is nodding her head that she would be okay with a temporary, but she's not obviously in agreement with Dr. Holland's.
I would be surprised if she would. So that's how family court works. Someone's obviously not going to be happy with whatever the recommendation is. That being said, before I ask them, let me ask your client, because I would prefer to have 3 consistent days versus 2 and an extra day, so there's multiple exchanges. So if we spread out his time so it is joint physical custody, would it be easier to move it from Wednesday at 8 a.m. or make it until Saturday at 6 p.m.?
Wednesday.
You think Wednesday would be better?
Wednesday.
Well, no. Kids are here was my client's concern, Your Honor. I think that going the other way is a little bit better. Saturday.
Okay.
And there was one concern in the interim. Apparently, these kids are in magnet schools, and they're required to do things on the internet. And last I knew, I don't think that Ms. Perry's client has internet at his house. If that's not the case, then let me know. But there's a schoolwork situation that if they can't do work at the house because there's no internet.
Let me. Do you have internet at the house? They're saying yes, they have internet at the house.
They have Wi-Fi at the house. Okay.
Yes. Yes.
All right. No, I'm just.
Okay. So listen, all I'm trying to get is a continued date. We'll go ahead and you're okay with the Saturday?
Yeah.
Okay, we'll bump it out. So the temporary order will, again, without prejudice, it'll be Thursday at 8 a.m. till now Saturday. Let's make it 7. 6 is a little early. So we'll make that Saturday at 7 p.m.
Your Honor, can we have it where Mom is to drop the kids off at school on Thursday instead of coming down here for Dad to have to turn around and take them back up to the school?
I agree with that as well. Do you have any problem with that, Mr. Frizzell?
No, my client's nodding in agreement.
Take the kids directly to school versus come all the way
Yes.
to family court and then back to school?
Yeah, that's not having to come to family court, just taking them directly.
Okay. All right. So they're
Fantastic.
All right.
Thank you.
So Ms. Perry and Mr. Frizzell need to have their conference, and then we'll see how long it will need to take to get prepared for trial. So I know you both are very busy, so and it might even take more than. I would suggest you have your clients there, because again, that's going to be more, so you don't have to keep going back and forth and back and forth and back and forth, or at least have them available by phone.
I don't have the availability of a conference room type situation.
No, that's fine.
But
so even if you guys do it by phone conference and have your clients in your respective rooms and both be on speakerphone, I think that's just as.
We can always meet up at the Texas station and eat over lunch. It's harder to fight if you're breaking bread.
That's up to you and Mr. Frizzell.
See, he's laughing about that.
Yeah, that's up to you and Mr. Frizzell.
Your Honor, and the child support, since it's now joint physical.
well, I mean,
I'm disabled.
she's not working. So if you want to do that, then we're talking. Hers is $200 a month, and his is whatever it is.
Well, his gross monthly is listed at $1,600, which is basically just barely over minimum wage. And unless you can tell me why your client can't go out and get a minimum wage job, then I would probably consider just even.
She's disabled, Your Honor.
Your Honor, she has their company. Why isn't she making any money from that company?
Why
We're not.
disabled by the government?
Her court hearing is in November for finalizing. I don't know if it's a court hearing or what type of hearing, but it's a disability hearing next month.
Your Honor, I requested that information in my discovery request, and nothing was ever turned over. And you do not get something from Social Security that fast.
Listen, for right now, again, without prejudice, I'm not gonna. I will cut it in half, Miss Perry. I'll make it $200 per month. But unless Mr. Frizzell, I get an order where, and again, she's probably going to get some sort of monthly paycheck, or I'm sorry, some sort of disability check, which I'll have to pull up the case law, but the court that is considered income, I believe, under the case law.
I do agree with you.
So for right now, just again, temporarily, if he hasn't paid it yet, this, I guess we'll start it, since we're at the end of the month anyway, so starting in October, it will be reduced down to $200 per month without prejudice. Again, we're noting that it is joint physical custody. So you guys tell me the status check date where you guys come back and say, we just can't work it out, Judge, go ahead and give us a trial date. 2, 3 weeks, 30 days?
Let's do 30 days. I know I've got 4 trials coming up real fast over the next.
Well,
30 days.
and my October trial schedule for my criminal trials sucks, for lack of a better term.
We got bad October.
I would say, would you be amenable to 45, Mary?
Okay, that sounds good to me.
That will get us right before Thanksgiving, so that would be, we can do the same thing. If you're in the building, feel free to appear. If you're not, we'll call you at your office, but we'll go November 19th, which is a Monday at 1:30.
All right.
And if in fact the matter completely resolves, then I'm sure Miss Perry would love to whip up a stipulation in order, not only putting all the terms into writing, but vacating that date as well. But
I know she would.
Yeah, but I think he's a lot more logical at putting it down on paper, right? But yeah, I would do it.
All right, Miss Perry, Miss Perry offered to. So, otherwise, we'll be back on the 19th, and we will. Again, I'll note for the record that if in fact it goes to trial again under the local rule, Dr. Holland's report comes in automatically. Either party can, on their own dime, and she's going to want. I think she requires half a day pay to actually appear for a hearing. So, but that's going to be at the cost of whoever wants to bring her in.
And Your Honor, and if the decision is different or is the same as what the report is, attorney's fees and
That's
costs?
always up for
Thank you.
consideration. At this point, however, given the fact it's still being negotiated, and if in fact an
Yeah.
agreement does work out, I don't want attorney's fees to make or break the day, because
Correct.
case law under DIMIC indicates if there's an agreement, it's just assumed that each party bears their own.
Yeah, well, I mean, I'm just talking about if there's not an agreement, it goes to trial.
Right.
Both parties need to understand that it could cost them more.
That's absolutely a chance.
Thank
So.
you.
All right, we'll talk to both of you November 19th. Actually, that's the week of Thanksgiving, but we'll call you at your office if you're not here.
All right, sounds good, Your Honor. Thank you, Mary. We'll get in touch maybe next week.
All right, I'll look forward to you calling me.
All right, thank you.
Have a good day.
You guys too. Bye-bye.
Bye-bye.